A2 to A5 are committed. And are now properly in the jurisdiction of the High Court. Your Honor, this case must progress. A1 is still absent today. She has been on criminal summons ever since the matter came up before this court. It has been, the criminal summons have been extended for several times. On account of her alleged sickness. Your Honor, we are afraid that whereas we have previously given a benefit of doubt, the information as relayed by our land brothers, the issue of sickness and all medical reports is a question of expert evidence and cannot be substantially explained from the bar. In the spirit of Section 55 of the MCA, 55, and in view of the fact that the criminal summons have not been honored on several occasions, we pray for a warrant of arrest against A1 so that she can be assisted to appear for the communication of her charges. Your Worship, the court system has a clear mechanism of handling issues of sick inmates, and so does the prison system. So we pray that warrant be issued as prayed.
Your Honor, for the record, Edison Katanga is my name. Your Honor, I thank my colleagues for their finally giving us the details of the charges. And while Mr. Mwaganya calls them alleged injuries, he would be well advised to read paragraph 40, page 8 of the indictment, where the alleged injuries have been classified by the DPP as grievous harm. I'm trying to state to his own indictment. Page 8, paragraph 40. Secondly, Your Honor, my learned friend has said medical issues are questions of evidence.
Paragraph 40 That's what I said.
She has previous harm. Yes, has previous harm. Secondly, my last friend has said, rather surprisingly, that he has been very gracious in the extension of criminal summons. I don't think we have seen any of that grace on this side. I think he has not failed to pray for a warrant of arrest on every occasion. The only reason why the summons have been extended is because of the medical condition of a patient who is still admitted in a hospital. Your Honor, the record will reflect that at the last hearing, on the 8th day of January, my learned friend conceded to the fact that the applicant was hospitalized. We do not discharge applicants from the bar. They are discharged in the hospital. Your Honor will also note that at the last hearing, on the insistence of the DPP, a medical board was constituted, found that A1 was still undergoing medical treatment. I don't know if the court has a copy or if I should avail the court a copy of the report of the medical board. Maybe I can.
Again, there is quite, I don't think we can be served with these documents because we don't have them.
We'll serve them. Of course, the DPP loves to be served, but doesn't love to serve. But we shall give them a copy of their report, which they commissioned. I don't know if they want us to have less copies. But it is their report, which they commissioned, which they shockingly deny. And I'm actually surprised that they denied. But anyhow, we shall give you as many copies of your report as you want. I don't know if each of the councils wants a copy of their report. However, Your Worship, that being said, we have this morning received a letter. Okay, the report, much obliged. The conclusions of the report are very clear. They recommended.
Firstly, this morning we received
No, before that, my Lord, forgive me. If I can go back to the report. My Lord, the conclusion of the report at page 3 says that Mrs. Katanga is a 53-year-old lady who was admitted in CKHK Hospital on the 2nd of November and had suffered multiple scalp lacerations. Those are very many head wounds, fractures involving both her upper limbs, and was in hypervolemic shock. That means she didn't have enough blood moving in the organs of her body. As per the evaluation, today, the 3rd of January, she's alert and coherent but has dizziness and is distressed. She is still this is about her situation. She is still undergoing medical treatment. Number 3, a statement can be obtained from her while in hospital. And in fact, that was done. So, it's important, according to the indictment, that was done. So what my land friend is asking this court to do is to issue a warrant of arrest for a person in a hospital who has not been discharged. I don't know if he wants the police to storm the hospital and discharge the patient. I know they have tried it before, but I pray that this court does not join the business of discharging patients either from the bar or the bench. Your Worship, this morning the state will take some comfort Your Worship, this morning we have received a letter addressed to the next of kin of the patient updating us on the medical condition. Your Worship, just for the purpose of completeness, we had previously served on this court a letter dated 14th December 2023, and we had given the DPP a copy. Maybe they want another one, but we're going to them in court. So before I speak to the letter I'm speaking to right now, we had previously written to, IHK had written to the Director CID and to the DPP, and had attached evidence of an operation done on the patient on the 12th of December 2023, and had said that the estimated healing period post-surgery is anticipated to be 4 to 6 weeks. Actually, that was on the 14th of December. That letter has been, I think it is on the court record. Today we have got an update. She successfully underwent her 5th surgery on the 12th of December and was to remain in hospital. For 6 weeks. We have been monitoring her progress and the necessary care. We are optimistic about her recovery trajectory and are scheduled to conduct a comprehensive final review on the 25th of January 2024. Feel free to reach out in case you have any details. Thank you for your ongoing trust, blah blah. Your Worship, the hospital is clear. They have the patient and they gave themselves 6 weeks. They wrote to court and gave themselves 6 weeks. 6 weeks expire for them to do their review, and they will do their review. In the event they are ready to discharge the patient, we undertake to bring the patient to this court as soon as she is discharged. There has been no medical evidence provided by the state to the contrary. What my land friend wants to do is to turn this court into an appellate body of the medical board, and to change this court into a hospital. No one is more anxious than our client to have a day in court. And as counsel, we undertake that as soon as our client is discharged, if the discharge happens this week or whenever, we shall deliver our client to this honorable court. And really our undertaking as counsel can be given from the bar, and worship can be taken by this court. So in conclusion, just to go through the history of the matter, from the very first appearance, it was the DPP themselves who informed court that the patient was hospitalized. On the 8th of January, it was Mr. Jonathan Mwagana himself who, after asking for a warrant of arrest, then said that information like the medical reports don't reach him on time, that the DPP is not fond of communicating because it's a very big office. The information doesn't reach him, but he said he concedes that A1 is in hospital. Your Worship, I am rather at loss that someone is asking for an arrest warrant to be executed on a hospital bed. I cannot like A1 much. And they have their enemies towards her, but an arrest warrant on a hospital bed is really, frankly, improper, and is asking this court to do something incredibly improper. Nonetheless, Your Worship, the evidence from the hospital, my land, we have not been, the other point, we have not been making these claims merely from the bar. The evidence from the hospital has been in writing either to the state or to the police. So every time this court has extended criminal summons, this court has done so properly. We have been told of a review coming up to see after the operation. The hospital has gave us 6 weeks. They have always known of these 6 weeks. My prayer, is this court to be pleased to extend the summons, but we shall, and we also pray, Your Worship, that you give us your your benevolence that as soon as our client is discharged, notwithstanding whatever the date of the summons may be, we present her in court on the day of discharge. We pray that you extend the summons, but no matter the date of the summons, if our client is discharged before the date of the summons, we shall present her in court as soon as she is discharged. And we're anticipating that they will be ready by the 25th to discharge her. So we pray, Your Worship, for your indulgence. No, we don't know that. We're not the doctors. But the letter says they're going to do a review. Remember, the first letter said they need 6 weeks. Those 6 weeks, I think, expire on the 25th. So they said they're going to have a review of her on that day. And I think that's what their second letter is saying, that they are monitoring their patient. And what we are saying is, while we pray for an extension of the summons, in the event that she is discharged earlier, the court to be pleased to allow us to produce A1 as soon as she is discharged, if it is earlier than the date of any summons. Then the issue of maybe my land friends will guide us on that one, on a separate issue of the indictments that have just been read. We hope that we shall be seeing the disclosure of the evidence supporting those indictments as soon as now, so that the accused person can adequately prepare their defenses. And I know that the state will probably want to hold on to them until the last minute, but we are praying for your charity on this one.
I don't know if I can just add something on the arrest warrant of A1. My Lord, we have taken exception with the way our senior colleague is conducting this matter. The last time, when one writes warrants of arrest, last time he asked for a warrant of arrest. First of all, we didn't charge it. Can we have a chair for A2? A2 is and well. A3 is and well. If the court can be gracious with the chair, you can borrow one from the members of the fourth estate. She's been standing for long. Just like me. A1 delivered on the 19th, A3 delivered on the 19th of September and was charged by the DPP on the 22nd of September.
We need to be guided. We have a lot of things to do, and now when you comment about A3 who have already been committed to the High Court, our concentration is on A1. We don't have to request each other here.
I'm talking about the warrant to A1.
Yes, concentrate there.
Yes, my Lord. And when we talk, the time runs out. When my colleagues talk, their time doesn't run out. Maybe because what I'm going to say is uncomfortable, but we must say these uncomfortable things here. This is our only way to say them, my Lord. And like other people who say them to the press outside, this court shouldn't guard me. Because it will say what I need to say. So my Lord, Your Honor, Section 53 of the Employment Act provides for a time of maternity leave. My colleague got a warrant when somebody was supposed to go to maternity leave. Now, yes, now, I'm coming to this one. This is the precursor to this one. My road, we came from somewhere to arrive here. And that road is uncomfortable. I can understand why the court doesn't want to go there. But I'm warning the court not to go the same road by issuing this one for a patient. That's where I'm coming from. My road, this is the first court. There are 3 courts after here. And that's why I want this to be on record, because of the way we are conducting this matter. So my road, what I am saying is that the road we traveled then, we shouldn't travel it now. And please record me, my road. The state applied for a warrant of arrest for a fresh mother who has since been separated from her child. And the court granted it. We are back to that unfortunate day where the state is again applying for a warrant of arrest for a hospitalized 53-year-old woman who the state has described to have grievous harm in their indictment in paragraph 40. My lord, I invite this honorable court not to travel that same slippery road. We have traveled that road before. We have a young mother in jail. We shouldn't have a patient in jail. The court shouldn't able the DPP. I don't know what the DPP has agreed to do. Whether the last bit of prosecution has become into persecution, but this court, I invite the court not to travel that road with the DPP, to reject the prayer for a warrant and extend summons until the accused A1 is healed and discharged. And only then, why are you in a hurry to try A1? What if she dies in hospital? Wait for her to be discharged and then try her. There are enough cases to try my road. That's why I was giving you a history so that we don't travel that road again. We require a chair for that fresh mother. Should we require many chairs for the new one? Let's not travel that road again, my road. That is our prayer. Allow A1 to heal, and then we can charge her. Let's not specialize in arresting young mothers and patients from their hospital beds. If the police wants to do so and the prosecution, let them do so without the aid of this court. This court has aided them before to arrest a fresh mother. You should not aid them again. We are much obliged.
Your Honor, I didn't know that prosecution was a very difficult job. Indeed. But I know my colleagues know that we are here to simply do our job in accordance with the law. Your Honor, court appearance is obviously a painful process, but those subject to the law must undergo it, because that is the only road to take if justice is to be administered. So, Your Honor, appearance cannot be at the will or convenience of a party. Yes, we agree that in the indictment we mention a grievous harm, but Your Honor, that examination we refer to is as of the 9th of November last year. 9th November 2023. It can't be relied on as an authentic status now. Then, Your Honor, the report, this letter addressed to the next of kin dated and stamped today, just to be sure if court has a copy of this. Your Honor, this letter is not addressed to this court. Number two, it talks about 6 weeks, as from the 12th of December And the simple mathematics shows that actually 6 weeks, they said 6 weeks, have lapsed. But most importantly, this letter, even if it had been addressed to court, it does not speak to her inability to answer the court process. There's nowhere that the doctor is saying that A1 should not answer the court process. It is not there. But again, Your Honor, we want to be very careful, and we invite this court to be, because like we submitted, that the system of waiving expert evidence from the bar by members of the bar who are not medical experts runs a risk of, one, misleading court on issues where our expertise does not lie, but two, it borders submission of evidence from the bar, which is not only an unacceptable practice, but which would also render such submitted evidence inadmissible. We, as members of the bar, cannot authentically explain expert reports. Then unfortunately, this is not also evidence that could be tendered and admitted for reliance. As I invite my learned senior colleague to sum up our rejoinder, Your Honor, I want to emphasize that the criminal justice system has a clear mechanism of handling sick inmates. This court is not short of the power to make appropriate orders if an inmate or suspect in this matter is produced before it. The prison system also has a clear mechanism. The prison system, specifically. Yes. 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 This is exactly, Your Honor, that I'm addressing. That the prison system has a clear mechanism.
Your Worship, we didn't get the question, but you had asked.
The question was, you said, what is not show proof? Now, you say, yes, we should warrant us.
The prison system.
The court. Put that down before the prison report.
I am very alert, if I may be allowed to mention. Prison system has a clear mechanism of handling sick inmates. In fact, as this court may be aware, there is a whole hospital. Now, this is a matter of judicial notice. That there is a hospital in Makshon Bay, which is part of the prison facility, where I am trying to address. Yes.
And that's why my landlord is asking for the court to discharge the patient and admit her in another hospital.
Relax. You see, the court has asked me to demonstrate how the system deals with the scenario. You know, you're under Makshon Bay Hospital. is a retention facility for inmates that are unaware. And Your Honor, it's also a question of judicial notice. That if the prison doctors, who are equal professionals in the medical field, assess that they cannot handle a specific situation of inmate X, they even make referrals to Mulago National Referral Hospital. I want to submit, Your Honor, that this system exists to address situations such as this, where sickness may be used to curtail appearance of persons who are subject to court process. I invite my land sister
that is entrusted with the law under the Constitution to treat all persons equally and without discrimination. Your Honor, as I talk now, we have very many inmates in New Zealand who are sick. We even have now mothers giving birth in New Zealand, but answering to court. These are not any special, Your Worship. Your Honor, in a criminal trial, there are very many stakeholders. We have court, we have the DPP's office, we have the public, we have the relatives of the deceased who are also looking for justice, but we also have 4 other accused persons who have now since been committed to the High Court.
Your Worship, I am afraid my senior colleague is bringing new matters. This is a rejoinder. The issue of stakeholders, the issue of complainants was never raised. I don't know where she's bringing that from, unless we're going to be allowed to respond to it, Your Worship.
Your Honor, it is common knowledge that all these are parties to a criminal trial. And all these people, Your Worship, we all can't receive justice because of only one person who has, on several occasions, absconded from appearing in this court, even when court has been gracious in giving criminal summons. We therefore reiterate our earlier prayer that this court be pleased to issue a warrant of arrest against A1.
I've raised 2 issues that we didn't address. One of them is the issue of, which you actually asked him that he didn't respond, that if you bring here a sick person, what does the court do? What he responded to, Your Worship, is what does the prisons do, not what does the court. There were 2 issues. He says there's a system for court, there's a system for prisons. Yeah, so prisons is so different from you, Your Worship. I wanted to respond to that issue and the issue of that is the second option. The first option was court, Your Worship. The brief rejoinder I would like to make there, Your Worship, is 1, the accused has never absconded. It has really been them who prayed the first time. Okay. Number 2 is that the accused is still on a hospital bed, and therefore all we are asking for, Your Worship, let her finish treatment, be discharged, and then we can continue the court process. Your Worship, I think the last part on the stakeholders, I don't think the stakeholders want somebody to be discharged and the person loses their life. I think everyone in this case wants justice to happen. And justice now justice now requires that we allow discharge, which is a medical functionality, to take its course, Your Worship.
Okay, now,
Look at the
because you mentioned that the 6 weeks have lapsed. They have not.
but if I can remember, we were here when was it?
We're here on the 8th.
8th, and this court is making a ruling on whether to issue warrant of arrest. This matter first came in this court on 21st of November 2023. Accused number 1 and accused number 3 were not in court. It was submitted that accused number 1 was admitted in hospital, and accused number 3 was a new mother. Court issued a criminal summons for both and adjourned the matter to 4th of December 2023. On the 4th of December 2023, the state applied for warrant of arrest, and Mr. Karuhanga told the court that accused number 1 was still admitted and had serious injuries. He showed the court some pictures, and the court extended criminal summons for both accused number 1 and accused number 3 till 18th of December 2023. And on 18th of December 2023, counsel for the accused attempted to apply for bail in respect of the accused who are present. That is accused number 2, 4, and 5. And I declined to entertain the bail application, and they said that the court, with the jurisdiction to handle the grievous offense, would handle bail application. Accused were further remanded, and the criminal summons was extended in respect of accused number 1 and accused number 3. This matter came up on 8th of January 2024. Warrant of arrest was applied for in respect of A1 and A3, again by the state. Counsel court issued warrant of arrest for accused number 3 after hearing that she was attending hospital from home but could not attend court. For accused number 1, criminal summons was extended to 22nd of January 2024, which is today. 2 days after 8th, that was on 8th of October, 8th of January 2024, accused number 3 was brought to court by her lawyers. Now, as regards accused number 1, she has been on criminal summons since 21st of November 2023. Today, the accused counsel are applying for extension of criminal summons, saying that accused number 1 is still unwell. They have shown court a letter addressed to the next of kin on the medical condition of accused number 1. Though this letter is not addressed to court, and even affidavit sworn by medical personnel accompanying the medical report, or a letter or someone showing that these people an affidavit sworn to that effect, and they brought to court. On the letter dated 22nd January 2023, I believe it's a mistake. It's 2024. In the letter is indicated 2023. I believe it was written today, 2024. Yeah, you can look at it. Yeah. In paragraph 3, it was said that on 12th of December 2023, a successful A1 successfully underwent her 5th surgery and would remain in hospital for 6 weeks. As observed by State Jonathan, I've counted the 6 weeks, and they're ending tomorrow. As court, we really don't understand the condition of the accused. And I agree with the state that there is a mechanism in handling sick people. There's hospital and prison. Also, the accused, if the accused brought in warrant of arrest, can apply for bail to the competent court on the basis of her condition. This court will therefore go ahead and issue warrant of arrest in respect of accused number 1. Briefly, these are the point of course that the one that accused, we don't know the accusation they accused as court apart from reports to the DPP, letters. 2, we don't have an affidavit sworn by a medical officer, personnel, addressing that show that accused. 3, if accused brought on warrant of arrest, can apply based on her condition to go to the competent judicial, or if taken to prison, can attend hospital from prison. And since now this matter is committed to High Court, we give it a date.
We try for the date of the prosecution to execute
We can do it two.
only with respect to the A1. So as I'm
For 12th of February, formation A1. Oh.
Nothing about program.
No, 12th, she's study saying we give a date for management, case management for me. In respect of accused. Yes, yes.
So today, first of all, after so many tricks, we have been engaged in a trickster arrangement with the DPP. After so many tricks, finally, they have committed the accused to the High Court for trial. And that's very good. For us, that's a good development. And finally, we have seen the evidence against our clients. So that's a good development. The second development also, which is both good and bad, is that the court has issued an arrest warrant against our client. And as our client is a law-abiding citizen, we're going to discuss with the medical team at the hospital and make sure the client answers that she wasn't ready for discharge. But when you have an arrest warrant, you must comply with court as a law-abiding citizen. So we shall also discuss with the hospital and bring our client to court to answer the warrant. We won't wait for her to be arrested because she's immobile. She can't move. She has monitors. She has many things. I visit her twice a week, so I know from even observation. So we will answer that warrant. But the good part of it also is that the bad part of it is that you can't issue an arrest warrant. We don't agree with the warrant. You can't issue an arrest warrant for somebody who was battered to near death, even after 5 experts of the Ministry of Health from the medical board have told you so. In fact, they recommended that police go and record a statement from her hospital bed, which they did in our presence about a week ago. So, but we are where we are. We will deal with it.
Counsel, do you agree with court that it did not bring experts to explain to court what is happening to your client?
No. There is an expert report done by 5 experts on the 3rd of January about the state of her health. It is there. I can give you a copy for free if you don't have it. Signed by 5 experts, led by Dr. Chiriawire. 5, and those ones were commissioned by the DPP. So which more experts do you want? If you bring private experts, then what about the government report of 3rd January? Today is what? It's 22nd. So except if somebody has a miraculous recovery, you can't have recovered from 3rd when the experts visited. In fact, the last time we had a meeting with her, she insisted on coming to court. She thought we were the ones lawyers until we called in the doctors. And we said, no, we can't do that. It would be reckless. We lawyers can't make that decision. If the doctors are fearing to bring you, for her she was saying, no, I want to go. But we said, you can't stand. She said, no, I want to go in a wheelchair because I am tired of this place. You know how when you spend a long time in a hospital, I think that despair had set in. But also the medical people had said, we need 4 to 6 weeks to review you. But for her, she wanted to come.
So she's really anxious to come. That's actually true because we were there together in the meeting. She will be. An arrest warrant has been issued. You will see her, but the health status is in the report dated 3rd January by 5 eminent doctors of the Ministry of Health. There is a report, you people, 4-page report. It details everything. The New Vision attempted to summarize it. You need to read that report. So me, I'm not a health expert, but the report is by experts commissioned by the DPP. There is a health report by 5 experts.
Counsel,
buli lunaku naye kwasaka n'akasonga nayongerayo omusango nayongera tubadde mweyembeere yajangu onkwekule kati olwaleero ewedde kubanga balaze baba committees mu high court ne balaga n'obujulizi obugenda okuleetebwa ekyo kirungi omusango gutandike kubanga emabega babadde mu kwekwasa obusongasonga baddeleyinga kino baddeleyinga kati olwaleero kikoze eki kikomye kakati ekiddako kino ekyekibaluwa ekyabakuntumye tugenda kwogera n'abasawo omulwadde abadde tanabeera bulungi naye ekirungi abadde akubye ku matu nga atandise physiotherapy bamutambuza so tujja kunnyonnyola eddwaliro nti limute kuba naffe tubadde tulinda eddwaliro limute naye olw'okuba kooti emutumyeko ekibaluwa tujja bagamba ekibaddewo bamute mangu tumuleete mu kooti ebinaddirira prosesi y'amateeka etambule.
Batutegeeza nti ayagala nnyo okujja mu kooti alongoose erinnya lye
oyo omukazi abasawo batugamba nti singa yamala eddakiika endala 3 nga tannatuuka mu ddwaliro yali agenda kufa kubanga yali aluuzinze 80% omusaayi omuntu gw'alina okubeera nayo mu bulamu olwa injuries yali afunye ku mutwe. Kakati oyo omuntu yali mu mbeera ng'eyo amaanyi agafuna emmundu n'agikookinga n'akuba amasasi nze naawe ebyo katulinde banaabitugamba. So ayagala nnyo okujja era olwasembayo yali ayatugamba njagala tugende mu kooti olwa summons ne tumugamba ffe nga balooya tetusobola kukola decision eyo abasawo nga batugamba nti tunaba kubeera ki redde tujja kubeera reckless bwe tukutuusa mu kooti n'okugwirayo. Kakati ekirungi bamutandeko ekibaluwa bw'anaagwa mu kooti si musango gwaffe nga balooya ffe twagwejjako kubanga ffe twali tumugamba tulinda abasawo kye banaatugamba era ebbaluwa z'abasawo tubadde tuzireeta enkya n'eggulu nga tuziraga ki kooti ffe tetuli basawo tuli banamateeka. So